Supreme Court sided with the maker of Roundup weed killer today, blocking lawsuits that claimed the company failed to warn consumers of cancer risks.
The Supreme Court obviously has an incredible amount of power, but should it? Must it? Or is it time for reform? Joining us now to discuss his upcoming book, The Hidden History of the Supreme Court and the Betrayal of America, New York Times bestselling author and host of the Thom Hartmann program. Thom Hartmann, welcome back to the show.
Hey, John, great to see you again.
Great to have you here. I found your book really interesting, a history of the Supreme Court, and like specifically talking about some of the biggest issues with it. But I guess I should let you explain what's the focus of the book this time around.
Well, there were a couple of big stories that I wanted people to get. The first is that the court has, particularly over the last 60 years or so, become an extremely political instrument. It's not the apolitical, we're just calling balls and strikes that they try to pretend they are, particularly when you throw in this made-up fantasy that Robert Bork came up with of originalism. We can read the minds of the founders, just like Jimmy Swaggart tells you he can read God's mind. It's just as much of a scam. Secondly, that the Supreme Court has taken power to itself that the framers and founders never intended for it to have, or at least many of them never intended for it to have. And that has distorted our politics and our law in substantial ways. And the third is that Congress has a set of powers to basically control and, to use the language of the Constitution, regulate and provide exceptions to what the Supreme Court can do that Congress has virtually never used and really should seriously consider using. And so, those are kind of the three big takeaways.
So let's talk about one of the big powers, and you were sort of alluding to this earlier. That is judicial review. What should people know about this incredibly powerful, basically power that the Supreme Court gave itself?
Yeah, it did. Nowhere in the Constitution does it say that the Supreme Court can strike down a law by saying that that law violates the Constitution. The Constitution does not establish the Supreme Court as an arbiter of itself. It's very explicit and specific about what the Supreme Court can do. That they're the first court of jurisdiction when it comes to international disputes, the first court of jurisdiction in debates or disputes between and among the states. But that when it comes to regular law, that they are simply the final court of appeals. That you sue somebody and then they countersue and goes back and forth, and eventually the buck has to stop somewhere. And that's what the Supreme Court was from 1789 right up until 1803, when in the Marbury versus Madison decision, the Supreme Court decided that they also had the power to strike down laws, saying that the supreme law of the land was the Constitution, and they were its arbiters, and therefore every other law had to be filtered through their understanding of what the Constitution meant. This so flipped out President Thomas Jefferson that he just went nuts. He went on a rampage. He said, under this doctrine, the Constitution has become a thing of wax. He said it's become a complete felo de se. He wrote in a letter to Abigail Adams, as I recall. Felo de se is Latin for a suicide pact. He said this makes it, in another letter to I'm forgetting who it was, but in any case, another letter, I think it might have been to Madison, he said, this, under this doctrine, this makes the judiciary the most despotic branch. And it so, created a huge controversy in the United States. And the outcome of that was that the court backed off. John Marshall never did that again. He was the longest serving Supreme Court justice in history, and he never did that again. It wasn't until 1856 when the Supreme Court Justice Roger Taney decided that he was going to once and for all settle the slavery problem, and in the Dred Scott decision ruled that all people of color in the United States could be bought and sold, period, full stop. And that, of course, led us right into the Civil War. And famously, Abraham Lincoln said, I'm not going to do what the Supreme Court said.
Yeah.
But that's pretty much all they do.
Yeah, and I think you do a great job in the book in making the case for how the Supreme Court has almost always sided with the powerful and the wealthy, using that power and others. What are some examples that you'd like to point out that were most consequential in that area? Well, the court has
over the, I don't know how many years it is, nearly 90 years, I guess, since the Wagner Act, the National Labor Relations Act, legalized unions. There were a few years there when they were on the side of unions, but starting in the 50s, really in a big way, they just started taking apart union power. And they've continued doing that right up to this day. They defend corporations over people regularly. They have always been the very last to defend civil rights on the occasions that they have. And most recently, John Roberts famously gutting the Voting Rights Act, which has led to, massive voter disenfranchisement. The list is long, John. It's a long list.
And look, I know looking forward, a lot of people are worried that even if 2020 leaves us with a progressive in the White House, Donald Trump's appointments to the Supreme Court have left it in a position where it might spend the next 2 or 4 or 8 years overturning key pieces of legislation. And so I know some people are thinking about the possibility of changing that in a number of different ways. One hypothetically coming from this book is reforms to change the status of judicial review, their ability to overturn legislation. How likely would you say that is to happen?
I think that's the least likely. I titled that chapter, and it was based on a memo that John Roberts wrote when he was working for Ronald Reagan, in which he was talking about how they could overturn the Roe v. Wade decision of 73 and the Brown v. Board of 54, how they could overturn those two decisions without having to run through the court and without having to do a constitutional amendment. And he pointed out that Article 3, Section 2 of the Constitution gives Congress the power to regulate the court and to provide exceptions to what it can rule on. So Congress could literally pass a law saying, states have to comply with the Voting Rights Act. And by the way, the Supreme Court may not review this. Mm-hmm. It would provoke a constitutional crisis because it's not been done before. But that power is explicit in the Constitution. And that's what John Roberts pointed out. Reagan didn't go for it. I don't think he ever thought that he had a large enough majority to be able to pull it off. But that would be one way to control the court. The other is court packing. And we've seen political court packing. Franklin Roosevelt nearly did this in 1937. And it was quite popular. The court had struck down child labor laws as unconstitutional. They had struck down long-term unemployment payments. They had struck down parts of the right to unionize. They had struck down, just a whole bunch of good progressive legislation. And they were fixing to strike down Social Security as unconstitutional in that court session. And it turns out, and so, Roosevelt said, okay, we're going to make every justice over 70 be a justice emeritus, and they don't have a vote anymore. Or in aggregate, there were 5 of them at that time. In aggregate, they have 1 vote, and then we'll put 4 new people on the court to fill it out. He ultimately didn't have to do that because Francis Perkins had a conversation, his Secretary of Labor had a conversation with the wife of Justice Owens, and basically convinced her to convince him to change his vote, which he did. And that was the end of that. But Roosevelt had a lot of popular support for that. Another one is after the Civil War, when Andrew Johnson became president, there was a vacancy on the court at that time that happened right around the time he became president. And the Congress, hated Johnson, and that's why they impeached him. He was a slave owner. He was nakedly, sympathetic to the South. And so they passed a law within a week or so of his becoming president that reduced the number of members of the court from 7 to 6 so that he couldn't put anybody else on the court. Mm-hmm. And then, about a month after he left office and U.S. Grant became president, they passed another law raising the number of justices back up to 7. So, and that was very popular also. So there's a bunch of ways to get around the court. It's just been a long time since anybody seriously tried to do it.
Well, we might be entering a period where that sort of thing could be considered. The Supreme Court obviously not closely aligned with the interests of the American people in a number of important issues that are likely to face big legislative pushes over the next few years. So in advance of that, I think that people should definitely take a look at your book and get an idea of the history of this, where it might go from here. The Hidden History of the Supreme Court and the Betrayal of America. I believe it's available October 1st, Tom?
Yeah, it ships October 1st. You can buy it on online bookstores now, and you can put in a reservation in your local bookstore too.
Awesome. Thom Hartmann, thank you as always for joining us.
Thanks so much, John. Great talking with you again.
Check out the Damage Report podcast each day, wherever you get your podcasts, whether Pocket Casts or Stitcher or iTunes. You can join me as I give you the news and stories you want, with a range of co-hosts and interview guests jumping in on the fun each day. Again, that's the Damage Report, wherever you get your podcasts. And if you get them at iTunes, don't forget to rate and review. Sometimes I'll read them live on the show.